people have gone to school or minim law. Yet the Supreme Court judges almost law, so that is why they're on the bench. But that ruling which came from the Accra High Court allowing the EC to do recollation, it is void. It is void. That is what at Sampson in some of the Ababe to journal. Now, what he said in his entirety. The
law says also that once the gazetting has been done, within 21 days from the date of the gazette, anyone who has any complaints about the process must approach the High Court. I repeat, High Court, not the Electoral Commission. CI 127, on the basis of which the NDC insists that recollation is unlawful, is spot on. They are absolutely right to say for all constituencies where collation has already taken place, there cannot be recollation. Now check CI 127. You will find that there is no mandate after the returning officer or an officer so appointed who has made the collation and the declaration. There is no room for recollation and redeclaration where the collation has been done and the declaration has been done. Now, Raymond, check the Act 284. At 284, let's look at specifically Section 20. Section 20 concerns grounds for cancelling election results. This ground must be canvassed in a court, not before the Electoral Commission headquarters.
The video of them.
So it says these are the grounds: general bribery, general treating, general intimidation, or other misconduct or circumstances, whether similar to those specified in this act or not, have so extensively prevailed that they may be reasonably supposed to have affected the result of the election. That there has been non-compliance. Raymond, mark that.
Okay, non-compliance.
Talking about what? Non-compliance.
Non-compliance, anyway, yeah.
That there has been non-compliance with a provision of this act, or, mark that again, or of the regulation, and that it appears that the election was not conducted in accordance with the principles laid down by law, and that non-compliance affected the result of the election. Or C, that a corrupt or illegal practice was committed in connection with the election by the candidate, or with the knowledge or consent of the candidate, or by an agent of the candidate, or that the candidate was at the time of the election a person not qualified or a person disqualified for election. So once a collation has happened and a declaration has occurred, my respectful view of the law, which appears to be the plain reading of the law, not that I am seeking to interpret it, is that there cannot be a recollation. If the collation, whether it was marred by whatever conduct, as the law says, whether it was marred by intimidation, it was the result of a duress, whether or not the person who did the declaration is not qualified, and whatever the reason may be, the forum where a recollation may happen, the forum where recounting may happen, the forum where a new declaration may be occasioned is not any place other than the High Court.